Good afternoon, everyone. Thank you so much for joining us. I do apologize about the delay in getting started and having your screen pop up, as technology is great when it works. So thank you for joining us. And just a few housekeeping items. This webinar is approved for 1 hour law CEU. You can only use it once during the biennium, even though we do give this seminar every year, just because the information is so good and everyone always has questions on this topic. If you are getting CEU for this, you will need to wait about 7 to 10 business days for it to pop up on your portal. And Michelle will be sending you a letter in the mail giving you information on your CEU as well. If you have questions during the webinar, and I know there will be a ton, please type them in at any point. And when Mike gets to the end, we will answer all of your questions. At this time, I'll turn it over to our Executive Director, Mike Linati. And thank you so much, Mike.
Thanks, Kelly. Good afternoon, everyone. Thank you for joining us today. As Kelly said, this is one of our flagship CEs, simply because it is, I would say, the most popular section of law that we get, and by we I mean Kelly and I get, in terms of compliance questions into our hotline. For a law that's not very long and relatively straightforward, it seems like you would be amazed at well, maybe you wouldn't because you're doing this every day, but we are a little bit amazed sometimes about how many different variables there are that impact the decisions that are made. So I will not whiz through this too fast, but I will make sure that I am done to give everyone time to ask their questions and to get through them in the hour that we've allotted ourselves. If you have taken this in the past, hopefully you'll recognize a lot of what's being said, because it really hasn't changed too much. But again, this is something that we know is important for you to keep getting refreshers on, or just reminders on, so that you're able to address these situations as they come up. All right, let's see now. There we go. So the law that we're going to walk through is in the public health law. It is section 4201 of the public health law, and we've affectionately called it the final disposition law. This law was first put into effect in 2006 and has subsequently, it's been amended 3 times, once in 2007, once in 2012, and again just last year in 2022. We will touch on the 3 amendments as we go through the presentation. The reason for the law was to help with 4 distinct areas, which we listed here as the purpose. The first, and probably the most frequently talked about, is the priority list or next of kin hierarchy, which we will go through in detail. It also was enacted to allow for the appointment of an agent, which is your legal representative of the decedent, to control the decedent's final disposition. It also creates liability protections, not just for those accepting responsibility as an agent, but also for you funeral directors who are taking direction from the folks who have the ability to control disposition. And then finally, and this area comes up more than you would imagine, it created some clear areas of how to deal with disputes and handle dispute resolution, which we will also touch on. So at the end of the day, this really became and has become a roadmap for funeral service. So if you go all the way back to 2005 and before that, so basically prior to the law, funeral directors, as you know, had to deal with the question of who controls a person's final disposition. Increasingly, we found funeral directors finding themselves in the middle of a disagreement or an outright dispute amongst family members as to the method or the procedure of a loved one's disposition. In addition, the landscape has been altered by the complexities and realities of today's society, which includes more non-traditional family structures. This factor presents emerging legal and practical challenges for funeral directors, who are also looked to by the deceased survivors to make the decision as to which of them has the legal authority to control their loved one's final disposition. However, as you all know, each situation is unique, and funeral directors are not always made aware of all the facts in a particular case. It's also extremely important to note that prior to this law, New York State did not provide funeral directors with any specific guidance as to how to handle these situations or any explicit legal protection when doing so. As all of you know, and all too well, funeral directors are often put in the uncomfortable position of taking sides with one party over another, and by extension, seemingly endorsing a type of disposition that could ultimately be found to contravene the wishes of either the deceased or the loved one possessing the control. Of course, the irreversible finality of cremation raises the stakes even further. So needless to say, the role goes well beyond a funeral director simply acting in the less risky, albeit important position of mediator or arbiter. Unfortunately, these situations and circumstances cannot be avoided, but thanks to the final disposition law, funeral directors have heightened levels of clarity in dealing with family disputes, as well as significant liability protections that have not been non-existent prior to this law being enacted in our state. One quick disclaimer before I start walking through, or just an explanation, I guess. I think most of you know that I am an attorney, and whenever I'm going through a legal statute, I want to make sure that I am using the words of the statute, because the words are chosen very carefully and they're very important. So I've included a lot more on the slides than I normally would, so you can see the actual language of the statute. I'm also going to walk through the law section by section in the order it is listed in the statute. So you'll see section 1, and we'll walk our way through to section, I believe it's 7 or 8. So it's not necessarily the stuff that happens the most, like the hierarchy. It's the order in which the law is listed. So first thing, and this is normal in the law, is that they always, if there's going to be terms that are going to be specifically defined for purposes of this law, they will put that in the beginning. There are not a lot of definitions. There are only 4, but we will walk through each of them now. So the first is disposition. And as you can see, disposition simply means the care, disposal, transportation, burial, cremation, or embalming of the body. So it kind of covers everything from when you guys take possession of the remains right up and through the point of cremation or burial. The second definition is a little longer and one that comes up a lot, and that is domestic partner. So a domestic partner means a person who is to another person, so one person to another, either together through formally a party to a domestic partnership under state or federal law. State law in New York does allow for a formal domestic partnership. This is actually an agreement. You would go and file this with the state or one of the municipalities. And once you actually have this in place, you would get a certificate showing that you've been approved and you and the other person are in a domestic partnership. Very uncommon in New York. We have not come across that very often, but it is a possibility. A second is that you can register as a domestic partner with an employer or with a federal, state, or local municipality. We know that registration is available both in New York State and under New York City law. I'm not sure if any other local municipalities have it or if they just rely on the state law, but New York City does have its own law in terms of registering as a domestic partner. So again, in a situation where a decedent has passed and someone's coming in saying they're a domestic partner, clearly if they can show that they're a party to the agreement or they've registered, it's a clear indication that there is a domestic partnership that exists. A third way is to formally be named as a beneficiary or a covered person under employment benefits or health insurance. That is something that was very specifically added because of the impact of having received benefits or insurance coverage being a big factor. So if you're named as the beneficiary, then that could be evidence of a domestic partnership. The last one, which is the most common situation we get calls about, is that one that's really relied upon with a totality. It's called the totality of the circumstances test. It's a bunch of different factors. No one is the most controlling. Having all of them versus 2 of them is better, but doesn't necessarily mean you have a domestic partnership versus you don't. So basically what you're looking for here is, based on the circumstances of their relationship, the more of these things that they can show that they are doing together, the more likely it will be that a domestic partnership exists. So for example, if you commonly own or lease property, real estate, house, things of that nature, cars, that would be evidence of a domestic partnership. Common householding. So common householding means that you trying to create a household unit, one household unit between the two of you. So it's not being roommates. It's actually not in just sharing a location or an apartment or renting out a house. It is actually creating a home together. Shared income and shared expenses actually go towards the common householding. So that would be things like utility bills, food expenses, internet expenses, like things of that nature. Anything that you're sharing on the bill, co-listed, would be evidence. Clearly, if you had children in common, that's evidence. If you signs of intent to marry or become domestic partners, you file to register, you have an agreement being drafted, you've expressed an intent to marry, you're engaged, things of that nature. And then the length of the personal relationship. So just like anything else, if you've been living together for 25 years versus 6 months, it's going to have higher weight in terms of the length of or the evidence of a domestic partnership existing. One important note for you as funeral directors is that the law nowhere in it requires you to obtain proof of a domestic partnership. So with that said, when we get calls, when there's a dispute involving whether a domestic partnership exists or not, we would often say, well, can you get any information from the person claiming to be the domestic partner of the deceased that shows that they created a household unit, that they have a mortgage together, that they are creating a household, one single household unit with invoices or bills that show that they were there? How long have they, and how can they tell you how long they've been together? Things of that nature. It's just to help protect you that you've taken these reasonable steps to ensure that you are doing your due diligence, so to speak. The other option is to pause, and we'll get into this a little later, and not do anything based on the dispute that exists. But the most important part is that you are not required to go out and get an investigator to make sure that a domestic partnership exists. That is not your responsibility under the law. Your responsibility is one of reasonableness. And we'll talk about that in a little while as well. So the law tells you what a domestic partner can be. It also has some pretty clear examples of when you can never have a domestic partnership, what it can't be. So if two people are related by blood or marriage, they cannot also be domestic partners. This is really basically the anti-incest rule that was created by the state. So that's the big factor right there if you're related by blood or marriage. If you're under 18 years old, you are not eligible to be a domestic partner. And that goes into our last definition, which I'll just touch upon now at the bottom of the screen. A person under this section of the law says it's a natural person who's 18 years old or older. So if they refer all the time to persons in the law and someone's under 18, then they don't meet the qualification or the definition of a person. I will give you one quick example. We had a call from someone who was the mother of a child who passed away. The mother was 16 years old, and the funeral director wanted to know if the mother could be the person in control as a parent. And the answer was no, because the person was under 18 years old. So the law says persons in this order can be in charge of final disposition. That person never met that definition, and therefore the law did not give them any rights. An adopted child of the other person cannot create domestic partners amongst two people, and anything that would show that you are related by blood in a manner that would bar marriage in New York to a person who's the lawful spouse of the other person. So kind of a wordy way of saying that if my uncle is married to my aunt, and it's my uncle's on the blood side, but he's married to my aunt, and I wanted to then go ahead and create a domestic partnership with my aunt, I wouldn't be allowed to under this law. I don't think that comes up very often. It'd be hard to trace it, but that is another provision in the law that prevents two people from being domestic partners if they meet that qualification. And I just went over what a person is under the law. All right, so now I'm going to jump into what is probably the most important part, if not definitely the one that we get the most calls about, and that is the priority list. So this is the second section of the law. This one was amended in 2022. The area that is highlighted and the area and the words that are in italics and underlined, that is the change in the law from last year. So I'm going to spend a few minutes just walking through this. So the way the law reads, it says the following persons in descending order. So you start at 1 and you work your way down, have the right to control disposition. Meaning if you get to number 3 on the list and you found somebody who can control, you don't go down the list anymore. You stop because that person has control. So you go down in descending order, provided that if there are more than 2 members of a class listed in subparagraphs 3, 5, or 7, the 3 highlighted, then if you want to ensure that there's control, you need a majority of the members of the class who are available. So let's just use number 3 as an example. If someone had, there's no agent, there's no spouse or domestic partner, you get to kids. If there are 2 kids, then you just need one of the 2 to agree. If there are 3 or more children, let's say there were 3, you need 2 of the 3 to agree. If there are 5 kids, you need 3 of the 5. If there are 4 kids, you need 3 of the 4. So you get how that works. In order to move forward, you would need a majority of the people in the class to agree to a type of disposition or all of the disposition aspects in order for you to be able to move forward under the law. And that was a change from in last year's to the law last year. So what is the order? So number 1 is a person designated in writing through an agent form or a will. That if the decedent has taken the time to fill out that form or create a will with the proper language that says, I want this person to be in control of my disposition, they are the person in control of disposition. If there is no agent, then you go to the person's spouse, or it could be the domestic partner. I'm going to go back and touch upon these in just a second, but I want to walk through the list first. If there is no spouse or domestic partner, then you go to any child 18 years old or older, with the caveat that I just mentioned about majority. Then it goes to either parent, then any sibling 18 years old or older, a legal appointed guardian, any person entitled to share in the decedent's estate, a duly appointed fiduciary of the estate, a close friend or relative who has a pretty good familiarity with what the decedent's wishes were. And then last and probably least is the public administrator or anyone willing to act on behalf of the decedent. You see the asterisk on 7 and the double asterisks on 9 and 10. I'm going to give you some more detail behind each of those. But let me just touch on a couple of things. So spouse. So back in 2011, 12, this is the 2012 change, New York State passed the New York State Marriage Equality Act. So spouse now includes same-sex spouses. So that is important to note if you have someone saying that they are a spouse. And kind of spouse 2 and 2A, you can't legally have both a spouse and a domestic partner. So if the decedent, say the decedent was married, separated, living with somebody else for 25 years, and the domestic partner comes up and says, I'm the domestic partner, even though the decedent was living with them, they can prove everything, they were never divorced, so they were still legally married. If at the time of the death, the individual was still legally married, then the spouse has priority over anyone claiming to be a domestic partner. So I just want to make sure that that was clear. Looking at number 3, it says any child. Questions often come up. What about stepchildren? Can stepchildren count as child? The answer is no. A stepchild is not considered under the definition of child for purposes of this law. It has to be a blood-related child. So that is how that works. The parent, we get questions about foster parents. Can a foster parent be considered a parent? A foster parent cannot be deemed a parent. In order for someone to be the parent, they either have to, the foster parent would have taken the step to legally adopt the child, which then puts them in the position of parent under number 4, or they'd have to be appointed the legal guardians of the child, which would put them under number 6. So a foster parent alone, if that's the status, would not be enough for you to be in control of disposition. And then lastly, although not on this list, I just want to mention one other thing that comes up a lot when it comes to the priority list, and that is powers of attorney. So we get a question a lot saying, oh, this person was the power of attorney of the decedent, so they have control if there's nobody else. That is not possible. A power of attorney is not on the list. They do not have the right to control disposition. The only thing a power of attorney can do, and this assumes that they have a power of attorney issue that gives full authority, not just limited to banking transactions or real estate transactions. If they have a fully vested power of attorney, they can appoint someone else as the agent on behalf of the decedent, but they cannot appoint themselves. So they are not able as a power of attorney to act because they're power of attorney. They cannot appoint themselves to be an agent, but they can step in the shoes of the decedent and appoint someone else to be the agent for that individual. All right, so now I'm going to go to the next slide and kind of dive into those asterisks I mentioned. So under number 7, where it says any person entitled to share in the decedent's estate. But it actually, the law says in the following order. So this is an exhaustive list, and this is basically a sub-priority list. So if you get down the list, you work your way down, no spouse, no agent, no child, no parent, blah, blah, blah. You get down to a person entitled to share in the decedent's estate. Say there's grandkids. Well, you stop right there. Grandkids get it. Say there's nobody until you get to grandparents. Well, then the grandparents can share in that. So this is the second list you have to go through if you get down to number 7, and you have to start working your way through those familial relationships. This section is also one of the sections that now has to rely on majority. So if there's 4 grandkids, and then 3 of the 4 grandkids have to agree. So you work your way down. If you get all the way down to first cousins, and there's 10 first cousins, you need 6 of them to agree. This is when it can get a little tricky, both identifying all the people or just getting them all. So you're more likely to get the estate attorney or an executor involved in wrangling everybody up so that you can make sure that you've covered everybody. Those would be those reasonable steps that we noted before in order to make sure that you are following the intent of the law. The second footnote, which deals with the close friend or relative who's familiar with the decedent's wishes, or the public administrator or anyone willing to act on behalf of the decedent. That actually says in the law, that underlined section continues to say, who completes an at-need written statement of person having right to control disposition. So this is different from the agent form, because the agent form is done prior pre-need. This is at need. So now you've gotten to this point, and that close friend or relative or the public administrator should complete the at-needs form saying, I have the right to control disposition because I know of nobody else above me who would have those rights. And that's because they're the last 2 on the list, and really the catch-all, the safety net, so that you as a funeral director have somebody to turn to if there's nobody else available. So that is just another caveat, that you need that statement filled out in order to proceed with either the close friend or relative or the public administrator or anyone willing to act if you get all the way down the list. All right, so, oops, I think I went too far. Yep. So now we're going to move from section 1 to section 2. This is really a section of law that tries to help with a lot of what-if scenarios that would come up under the final disposition law. So the first scenario would be next in line, right? So what happens if the individual appointed a decedent, an agent, or just the person who has rights to control happens to be a child, and they are one of these 3 things. They are either unavailable, unwilling, or not competent to serve. If they fall into one of those categories, then you either go to first another person in that same category who is available, willing, or competent, or incompetent, I should say. So for example, in my example, I have a child, right? So if you had 2 children, one says, I don't have anything to do with this. The other child you'd go to first to see if they would be willing to act in that position. If you don't have somebody else with equal priority, or nobody with that priority status is willing or available or competent, then you go down to the next person on the list. So in this case, if you had to go down the list, you would then go down to, I believe it's parent. Yes, you go down to parent if we were using child as the example. So that's how this section works. The standard for unavailable is, again, reasonableness. It's a favorite word used under law. So if the person is not reasonably available, then you move on to the next person. Again, you don't have to hire a private investigator to find the person. You reach out, you do your normal things. If nobody answers, then you move on. Just show that you made an effort, a reasonable effort, to try to find that person who you believe has the rights to control. So that's how that next in line piece works. What about when you have the person and you're working with them, the agent or the person who's on the list in control? What are their responsibilities? So the first is they have to carry out the wishes of the decedent to the extent lawful and practical. And what does the extent lawful and practical mean? It means things like if the estate doesn't have a lot of money, but they wanted some $20,000 funeral and the estate only has $7,000, then you would look at what resources are available, and they could change the wishes to accommodate what's available financially. And anything that they would do could be consistent with the decedent's moral and individual beliefs. There are not a lot of court cases that are on this law from New York. But I want to walk you through one that deals with this situation directly. This is from 2017. It was a court in New York City that basically shows you how this is supposed to work in carrying out the decedent's wishes. So here's the facts of the case. A woman died, leaving no specific written instructions as to how she desired to be buried. He had been divorced twice from the children's father and had purchased a cemetery plot with him decades ago. Her surviving adult children were the legal next of kin and by law the first in line to control her disposition. After her former husband's death, she, along with her sister, purchased a cemetery plot in her family's home country of Israel. In the years immediately before her death, she continually expressed her desire to be buried in Israel to her sister and her home health aides. While she did not put her exact wishes in writing, she did provide her adult children with the information relating to her newly purchased plot in Israel. So the children, they wanted to bury their mom in the plot she purchased with her ex-husband, and that happened to be located in New York City. The women's sister or the kid's aunt petitioned the court to override the children's decision to have their mother interred in New York City, arguing that they were knowingly going against what their mother had been telling others. So the court held an evidentiary hearing where they heard from the children, the sister, and the health aides. The court then ruled that she could be buried in Israel. And the reasoning was that the adult children's testimony focused primarily on what they thought their mother would say or do, rather than what she actually said. And as such, it did not represent the personal and direct knowledge about their mother's wishes. But the home health aides testified that they had actual conversations with the decedent where she clearly expressed her desire to be buried in Israel. So what this really comes away with is it kind of reinforces some of the key messages from the law, right? You have a responsibility as the person in control to carry out the wishes of the decedent. Survivors have the responsibility to fulfill their loved one's wishes. The decedent's wishes are paramount to the survivor's preferences. And anyone with knowledge or evidence that the legal next of kin is acting against the decedent's wishes may petition a court to halt that, which is why we say when there's disputes in this regard, you guys should pause and say, I need a court order and to tell me how to move forward. So an important takeaway, and something like we always recommend, as I just said, is when there's evidence of a family dispute or the funeral director has knowledge or reason to believe that the next of kin is not acting according to the decedent's written directions or expressed wishes, you should pause and get the family to go get a court order to direct everyone on how to proceed. So that's just an example of how this section of law would work under the court's decision. Another important piece and a question we get a lot is with regard to financial liability. So the law, nowhere in this law does it talk about financial responsibility. The agent or the person in control is not liable, legally liable or responsible for paying the funeral expenses simply because they're the agent and can make the decisions. So that's an important distinction. It doesn't actually help very much because if you have someone paying who's not the person in control, you can get into some disputes, which we are very familiar with from calls that we get. But that is something that you need to keep in mind, is that the agent has rights to control decisions regarding disposition, but no financial responsibility to pay. The second part to this section deals with a couple other pieces. One is a funeral director as a person with right to control. So can you, as a funeral director or your employee, be a person with a right to control? You can, but that person cannot receive any compensation or receive a financial benefit for doing that. So you can certainly serve as an agent or the person in control, but you can't financially benefit from serving in that role. The last part of this section of the law is dealing with orders of protection. This is tied to a law also from 2012 known as the Anti-Domestic Violence Law. So if I was the person, so I'm married, my wife predeceases me, there's no agent, I would normally be in control. If before her death, she had me subjected to an order of protection, restraining order, something along those lines, then I could not control her disposition, even though I'm the next in line. So if the person who was going to control was subject to an order of protection at the time of the death, they cannot. You go to the next person. Or if the person was charged with the individual's homicide. Very different from arrested or suspected. So again, I said the words in the law are very important. This is an example. We've had several situations where someone says so-and-so was arrested, or the local police are suspecting it's so-and-so. Okay, well, they're coming in to do arrangements. They have every right to do that until they're actually charged with the homicide. So again, just want to make sure that that's clear. Now, can you get around this provision of the law? You can if a court order is waiving this, what's called in the interest of justice. So ironically, the only other court case in New York that I'm aware of on this law was from 2020 up in Washington County, which is north of the Albany area. And that was, I'll go through that one for you guys as well real quickly. In this case, there was a woman, so this is a gentleman's wife, died in December of 2019, and she was cremated. Her ashes were given to her daughter because the wife had an order of protection against her husband at the time of her death. The husband went to the court seeking an order to control the disposition of the ashes of his wife. The husband sued his daughter and the funeral home for giving her the ashes. And then according to the court documents, the daughter stated that she had already scattered all of her mother's ashes in Lake George, and then she threw away the container that the ashes were in. So the court listens to the assertions of both the daughters and the husband, and the court's decision was that the husband was declared to be the person who has the right to control the disposition of the remains of his spouse. And further, that the temporary order of protection issued by the family court was not an order of protection within the meaning of 42012 of the public health law that would disqualify the husband from controlling the disposition of the remains of his spouse, and that even if it is, the waiver of the disqualification is appropriate in the interest of justice. So the court ordered that in the event the ashes or the box or container in which the ashes were delivered to the daughter by the funeral home would ever come into the daughter's possession again, then that she was obligated to immediately deliver the ashes or the container to her father or this person's husband. So I'm going to give you my two takeaways from this. So clearly the judge he even said it in there, the interest of justice was part of the court decision. That's what the judge used as his reason for his decision. But personally, I felt that this was very problematic because the judge interpreted the final disposition law in a way that is clearly contrary to the plain language of the statute when he opined that the order of protection issued wasn't one that would disqualify the husband. There was no disclaimer. If you're subject to an order of protection at the time of death, then you're disqualified. And he didn't say that there was no order of protection. He just felt that the one issued by the family court doesn't rise to this disqualification. I disagree personally with that decision. But again, here's another example as to why when there's a dispute, the best thing you can do is pause and go get a court order, because the court will direct you on what to do, and that will give you some additional protection. So the next section of the law we're going to go over is the actual agent form. This is where the law actually includes the agent form language itself. I'm not going to read the whole thing to you, but I will walk you through the highlighted sections because those are important. So obviously it starts off with the decedent putting their name in there, and then they're saying, just like in a will, that they're of sound mind and body. So they're going to say right there in that first highlighted section, here's the person I want who control my disposition. And then if they have any special directions, here's specifically what I'd like to do. Here's what I would make sure you're okay doing anything except this. That's that paragraph underneath where they can give specific directions. This helps make sure that the agent is carrying out the express wishes of the decedent. So if in that court case I told you earlier about being buried in Israel, if the lady had appointed an agent and said, I want to have my remains, or even if she just listed her daughters again and said, I want my remains to be buried in Israel, then it would have been very clear and there would have been no issue that the daughters could have said, I want my mom buried in New York City. We also have a provision in here that will ask if there are any pre-funded or pre-need arrangements. If you say yes, then they ask for the funeral firm name. Just important to note that the firm named in this form does not have to be the firm that handles the case for the agent designation form to remain valid. So it's more just so that those handling the case know that there is something there that they can rely on for either funds or just either additional direction as to what arrangements might have been requested by the decedent. Then you go into getting the agent-specific information listed, and the decedent, or at the time the appointer of the agent, that person can change their mind, right? They can also appoint successors. So let's say someone's named agent and we get to that point and we go back to that other section of law where the person's unwilling or unable or not competent. You would have the ability to look back at this form and say, oh, look, we appointed, Joe Smith as the successor agent. So let's reach out to Joe and see if he's now willing and able to serve as the agent. So you can have up to 2 successors listed, so that would then allow for that to happen. At the bottom, I didn't highlight it, but you'll see it says this appointment becomes effective upon my death. So this form does not kick in until the person dies. That is very different from a power of attorney, which we get a lot of, again, I mentioned earlier, we get a lot of questions about. We have a power of attorney, so that's the person in control. So a couple things. A power of attorney, first and foremost, is only valid while the person is alive. So when a person dies, the power of attorney dies with them. They have no control, no responsibility, no authority, no power once an individual dies. And this is when, obviously, a person in control of dispositions, rights, and responsibilities kick in. Second, we also get questions about healthcare proxies. Oh, this person was listed as my healthcare proxy agent. That also does not survive death, except for one piece of it. The only part that survives death is any anatomical donations chosen. But any other decisions about the person's healthcare proxy or any decisions they might have wanted or made as regard to their disposition, the healthcare proxy, the person who's been deemed to be on that form does not have power to control final disposition. You go to the list and you work your way through the list. That is very clearly stated in the law, the way you're supposed to go through it. As I mentioned, the person can revoke it. So anytime prior to that death, if they change their mind, say they had appointed their best friend and they had a falling out, now they want to renege or get rid of that person and appoint somebody else, or just not appoint somebody else, they have the ability to revoke the appointment. The form to be effective must be witnessed by 2 people. A funeral director may serve as a witness, no restrictions at all. Again, the only restriction is if you want to be the actual agent that you can't get paid, but you can serve as one of the witnesses. And the last part of this form is the acceptance and signature of the agent. So the important part of this at the end is you want to make sure that the agent is well aware of they're being appointed, and that not only are they aware of it, that they're accepting it. So they're accepting this responsibility. So now it assures the agent can't be appointed with both their knowledge and consent. So that's the purpose of the last part of the form. All right, switching over to the next couple of sections. The appointment of agent form, if it's filled out and the agent's available, then the agent is number 1 on the priority list, and you always go to the agent as the person in control. The other legal document that can be used is a will. But it's very important that you understand that the will has to actually appoint an individual, and it has to use language similar to the agent form. If the will says, my executor is in charge of paying all my just funeral expenses, the executor is not an agent, and the executor is only responsible for making payments. I mentioned earlier, just because you're in control doesn't mean you have to make payments. The executor could easily be the person who is responsible for paying out of the estate, but they're not going to be the person who makes the decisions. So I just want to make sure you understand this. It has to in the will say, I appoint Joe Smith to be in control of my funeral arrangements, or and like the agent form, to be in control of my final disposition, and I would like this, and they can put those details in there if they want to as to what it could be. So just because there's a will and an executor named and it says control my funeral expenses is not enough to say that that executor or executrix is now the person who's in control. Can the person who's filling out the will make the executor or the executrix also the agent? Absolutely, they can name them, but in that wording, that has to actually say that person's name again, and specifically tie it to language that says, I want you to control my final disposition or control my funeral arrangements. So that's how that would work. If you had a will and then right before you die, you appoint an agent, the agent takes over from the will. If you had an agent form and then you had a will, and the will had very specific language that was the same as the agent form naming somebody else, then that controls. So the bottom line is the most recent written instrument, the one with the closest date to the date of death, is the one that controls. I mentioned that the decedent can revoke it at any time, the agent designation. The way the law reads, it says the revocation can be done either 1, through executing a subsequent written instrument. So there you go, like that's the, I revoke this agent form and I'm going to complete a new one, something like that. Or, and I quote, any other subsequent act by the decedent evidencing a specific intent to revoke the prior written instrument, end quote. So that's a big old open area, right? If someone's like, what does that mean? What is a subsequent act evidencing intent? It can be anything. Does it have to be in writing? It doesn't say so. So if you run into a situation where you have a dispute and someone's saying they didn't want this person to do it anymore, they had a falling out and they're trying to claim that, my recommendation is always take a pause and say, look, there's some uncertainty in a dispute. I don't know. The law says someone could revoke it. I need a court to tell me who's in control, and take a pause there. Or there is an instance where you would automatically have a revocation, and that's if it's your spouse or domestic partner is the person who is in control. But then you get divorced or you're legally separated from your spouse, then that person's automatically disqualified. Or if the domestic partnership is terminated, then that person would disqualify. Now, I said you have to be divorced. You're separated is not enough. You can actually go to a court and in some instances have legal separation. If you are legally separated, then it's equal to a divorce in terms of this law, the eyes of this law, in terms of a person who can control. So legal separation or divorce would disqualify the spouse, and then you would move on to the next person. All right. A couple more slides. So last couple of sections, 6 and 7, and then we have one more. This is the liability protection, that third piece I was talking about in the beginning as the 4 purposes of the law. So a person, there you go, 18 years or older, acting reasonably and in good faith, there's the reasonable standard I mentioned, is protected from liability for representing themselves as the person in control, disposing of the decedent's remain if done in accordance with the law, or identifying a deceased person. So those are the legal protections to the person in control and what they're doing. Again, they have to be over 18 and they have to be acting in good faith and acting reasonably. On the flip side, the funeral director and the firm is also protected if you are acting reasonably and in good faith for doing any of the following: carrying out the written directions of the decedent sent forth in the form or the will, or carrying out directions from a person representing themselves as the person in control, but only when you get a written statement from the person stating that they are the designated agent on the agent form of the will, or they have no knowledge of the decedent executing a will or written instrument that names somebody else, and that they are the person having rights to control under the priority list. How's the best way to do that? We have created 2 forms. One is for an agent saying, I was appointed the agent and I am still the agent, that you would have them fill out. Or if you're not an agent, then you're saying, that person saying, I am the person in control. I know nobody else on that priority list above me who would have control. They sign that, and then that protects you because you are now acting reasonably and in good faith based upon what these people are telling you their powers are. Again, you don't have to be that detective, so this helps you in that regard. And then the last section of the law is the dispute resolution. So this deals with disputes obviously over the right to control disposition, where they can't resolve it themselves. The law says it shall be resolved by the court, which is one of the reasons why we say take pause. You cannot be held liable as the funeral director for refusing to provide services if a dispute exists until you receive a court order or a form signed by all parties saying who has control. If you are going to go the route of not going to a court, then you want to make sure there's a hold harmless clause. So what would that be? That would be the children come in and they can't decide if it's cremation or burial. So you say, okay, let the court decide. And then later on, they all come in, they say, no, we're fine, let's do burial. You would then say, okay, I need everybody to sign this form saying this is what you agreed to, and to hold me harmless and indemnify me from relying on this because you all agreed that this is the way you want to do it. So they can't come back later and come after you for having agreed to do it this way. So that is something we always recommend. Have it in writing and make sure that you're going to be held harmless if they come back and have subsequently agreed. Lots of times when you say you have to get a court order, they don't want to wait, and they miraculously come to an understanding amongst all of them as to how to go forward. All right, so I have a couple of questions that I'll pose to you with some answers. We'll walk through this and then we can open it up to some questions. So I'll put the question up and then give you a couple seconds and then pop the answer. Can a funeral director be appointed an agent and control of final disposition? Yes, but as I said, you cannot be compensated or receive a financial benefit if that is the case. True or false? The person paying the funeral bill automatically has the right to control disposition. False. So as I mentioned several times, not only that, but they also don't have the responsibility for paying. So just because you pay, you don't get control. And just because you control doesn't mean you have to pay. Is it possible for a person to be appointed an agent without knowing it? No, because you have to actually sign saying you accept the appointment on the form, so it's done in writing. So you can't really go ahead and say you didn't know. Do you need an attorney or a notary when filling out the agent designation form? You do not. However, you do require 2 witnesses, and again, a funeral director can serve as one of the witnesses. Is the funeral director responsible or required to obtain documentation for proof of a domestic partnership? So the answer is no, right? So not under the law. I mentioned that the person who is in control is going to be signing the at-need form saying they have the right to control. There's some protection for you right there when they sign it. You can, you have protection so long as you're acting in a reasonable fashion and under good faith. So again, if there is an ability just to get a couple of documents that say, here's how I can show you that with a domestic partnership. We own a house together, we own a car together, we have joint bank accounts, those types of things. That'll help protect you. If there is a dispute, you definitely want that. And if there's a dispute that you can't seem to have resolved, then you take pause and go get a court to give you an order as to who has control, if a spouse is claiming they have control instead. Are there any situations when the designated agent or legal next of kin may not have a legal right to control disposition? Yes, there are two, remember? An order of protection, or if you're charged with the homicide of the decedent. Here's a scenario. 3 children meet with you to arrange for their father's funeral. 2 children want dad to be cremated, the third does not. What do you do? Follow majority, because majority rules. Refuse to cremate because one's objecting. Tell the children you can't help them and direct them to another funeral home, or wait and direct the children to obtain a court order to determine who has control. Under the law, majority rules, and you can move forward. I've had folks joke with me and say, well, I'm going to tell them they can go somewhere else because I don't want the headache. Or they're going to say, I want a court order to see who has control. I don't think a court's going to give you that because the law is pretty clear that majority rules, but the answer is majority rules. Can the funeral director act, should say act, not act, can the funeral director act as one of the 2 witnesses required for the agent designation form? Yes, you can act as one of the witnesses with no restrictions. Just a couple more questions. The following individuals, which one has the highest ranking on the next of kin final disposition list? This is probably a harder one. An executor, a public administrator, a grandchild, or a close friend or relative? So grandchild is under number 7. An executor is not even listed. A fiduciary would be under number 8. A public administrator is the last under 10, and a close friend or relative is number 9. So grandchild would be the one on this list who would have the ability, or would be the highest ranking person. 2 more questions. True or false? A designated agent can refuse to serve at the time of need. True. If you are unwilling, unavailable, or not competent, you go to the next person in that same grouping on priority or down the list to the next person. And the last question, are stepchildren considered children when it comes to the final disposition law? No, they are not. Oh, I apologize. I think I lied. I think I have one more. I do. If a couple is separated but not divorced, is the surviving spouse still the next of kin? And I will go further to say if they are separated, not legally separated or not divorced, are they still the next of kin? Yes. So they have to be legally divorced or legally separated in order to no longer be deemed the spouse. All right, so that gets us through the presentation. We still have, oops, I went a little longer than I thought, but we can stay on the line for a little while later if people have questions. So Kelly, I'll turn it back over to you.
Yeah, definitely. We have some questions. So the first one is, can you just explain a little bit about, someone had said, I thought there was no domestic partnership in New York State.
So that is not true. There's actually a domestic partner law in New York. So the language that the final disposition law covers relates to and relies upon the domestic partnership laws in New York. So domestic partnerships are legally allowed in New York under those circumstances. And I know that there are many instances when domestic partners have had control of disposition as a result.
Okay, I have power of attorney of my uncle. Can I do an agent form appointing his brother to handle his funeral arrangements?
You can, so long as your power of attorney form is a general one that is not limiting your ability to what your powers are. So there's usually a laundry list with check boxes. If it's not where just one or two things are checked and it's a general durable power of attorney, then yes, you can appoint on somebody else and as the agent. You can step in the shoes of that individual, of your uncle.
Just recently, a spouse and the decedent's brother came in together to make arrangements. Knowing that there already exists a conflict with the spouse and a grandson, the spouse presented a copy of her marriage certificate. The grandson eventually presented a will stating he will be making the funeral arrangements. But the will also stated that the decedent is not married.
So
Oh,
that's a lot to
sorry.
unpack right there.
The spouse claims the will is fictitious, and the grandson claims the marriage certificate is false. This all occurred after a sudden death. The marriage certificate is dated 1991, the will 2015. Who has the right of disposition? This has yet to be resolved.
So I don't mean to laugh, but this is the stuff that we get, and I can't. It's amazing what people will do. So a couple of things that you'd have to know. One is, let's assume that both documents are actual and real. If the will, if the will actually has language in it, similar to the agent form that says that the grandson has the rights to make my final arrangements and control my final disposition, then in that case, if they're both valid, you would be able to rely upon the will, because that's basically an agent appointment and that would be above the spouse in a priority. But if you have this dispute, you're not supposed to go out and find out which one is legitimate, which one isn't. I would recommend at this point, unless it's very clear to you that one's false and one isn't, or that the language, and if one isn't and it happens to be the will and it has the very clear language that you can move forward on, barring anything that clear, I would pause and tell all the interested parties that in light of this dispute and the claims being made, I can't move forward until a court tells me who has control of disposition.
Yeah, and he wrote later on saying in the actual situation, the grandson was mentioned as the executor only.
See, and then if you're executor, then you have no right. So that doesn't help at all anyway. So if they're claiming the will and the only language in there is that the grandson was an executor, that's not enough for purposes of the law. So the spouse would be eligible to be the person in control. However, you still have that situation where the grandson's claiming that it's not a valid marriage certificate. Now, you only have to do reasonableness, right? If that person claims and presents you with something and then they sign the at-need form saying, I am the person and there's nobody above me, you are protected because you acted reasonably by relying on a marriage certificate. You're not responsible for determining whether it's true or false based on claims of somebody else. So in that instance, I think you could move forward because the will only names the grandson as executor without the additional language that would be needed.
Should the successors be made aware that they are named? Why do they not require a signature to acknowledge?
Yeah, that's a good question. We've always talked about that. My personal recommendation is you should ask the successors to make sure that they're willing at the time. I believe the reason that they didn't do that is that the successor really doesn't come into play and have to agree to it unless the individual appointed as the primary agent is unwilling, unavailable, or not competent. I feel that it couldn't hurt. I would personally, even just on the side where it has the successors' names, have them initial it or sign it themselves, saying that they're, basically something similar to what the other primary agent is doing. Because at the time, if the primary agent's not available, not willing, or not competent, you're going to go to the other person, and they don't have to be surprised by that because they know ahead of time. I see nothing that would prove. Legally, it's not going to hurt you. Practically, it's probably going to help you, because if somebody who's going to be appointed as successor is not interested at the time, then you should be moving to somebody else. So definitely something you can do, not required by the law, however.
If there are two children, do you need both to agree with this position, or does only one need to make the decision?
Yeah, so it's interesting, right? It says if there are more than two, then you need majority. So if it's two, then you only need one of the two. Um, it's a little tricky, a little tough to understand maybe why, because you have a split. We have always gone, and this is before 2022, whether it was two children, four children, whatever, even with majority, if there was one who didn't agree, we would always say, if you have someone who doesn't agree, stop and get them to all agree, or get a court to tell you who of the children you should work with. So legally, the answer is you can pick whichever one you're working with, who comes to you, because they're equal in priority status. So if one of them says they want to work with you and they come to you first, you literally could just work with them because they came to you first. Our practical advice is, if you have two children and they're disagreeing, to again pause and say, you guys need to come to some agreement, and then put that in writing with the hold harmless. Or if they can't, then get a court to tell you which way to go. Because the reality is, they're equal, but who knows who had the better relationship? Who knows who spoke to the parent last? They can all make different claims. As soon as you have disputes, you just have to question who's being forthright and completely honest. And you don't want to be left in the position of having to pick which one it was. So our advice is always, if there's two, they don't agree, either get them to agree and put it in writing, or go to a court.
On the agent form, while making a pre-plan, I have had several people question why they are signing under prior appointment revoked when this is the first agent form they are filling out. Would it be practical to have that signature section placed under duration?
What was the first part of that, Kelly? Like they were filling out a what form?
An agent form while making a pre-plan? And they're questioning why they are signing under prior appointment revoked when this is the first agent form they are filling out. I don't have the agent form in front of me to view it.
And I'm not sure, I don't know, that doesn't make practical sense to me, so I don't know how to answer that without seeing the form and the wording and how it's playing out. But if it is the first one, they shouldn't be revoking something else. So I'm not sure, and I'm not sure if they're referring to the revocation language in the agent form, or if they're talking about signing it under a pre-need form. So I'm not exactly sure. If they want to send us the forms, I can take a look and we can email them back an answer.
Okay. Question 1. The hierarchy indicates either parent. If parents of an adult child, never married, no kids, disagree, what is the best way to handle it?
Parents of an adult child, never married, disagree. So I think you're in the same situation as the two children who don't agree. Either get them to agree. Again, legally, you could go to either one. So you could go to the first person you came to us. My advice again is, I just feel that, especially if like one is looking at something like cremation, the other one said they want to bury, we always say pause and go and get them to either agree and put it in writing and hold you harmless, or get a court order, because they're both equal. So one's going to potentially be mad enough to come after you and say that this was unreasonable because, and da 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 da. So, and there's no way for you to know. So I would say, tell them to agree in writing or go get a court order. But again, like, I just need all to understand, legally, you can pick one and you are protected as long as it was reasonable. So the question always becomes, what was reasonable? And doesn't prevent anybody from suing you. It doesn't prevent anybody from dragging you through court. It doesn't prevent some judge from coming up with, I thought this was unreasonable. All you had to do is wait and get them to come and give them more time, or come to us, family court and surrogates court, and get that decision, which is why we're always taking that conservative approach and advising you to take that pause up front to get some type of agreement or direction from a court.
Okay, does an out-of-state written instrument signed by the deceased appointing someone to control disposition, and also signed by two witnesses, hold the same power as the New York agent form?
We actually had that question about a Florida form, and we asked the Bureau, and the Bureau said it doesn't matter what state it's in, or if it was witnessed out of state and it was a New York form, as long as it's clear that the person is appointing an agent, and it has very, substantially similar provisions as our form, then it's fine to, as long as it's signed and it is witnessed by the two witnesses, then you are good to go. So it doesn't have to be the New York form, but it has to have the components required under the law to make sure that you're covering everything that would be required if it was the New York form.
What if you have a completed agent form for someone and then find the obituary in the newspaper with a different funeral home and it doesn't mention appointed agent at all? What would you do? Let it go or call the funeral home?
You say that one again? I lost you in the middle. Sorry.
Yes. So if you have a completed agent form for someone, and then you see the obituary in the newspaper, and the person used a different funeral home, and it doesn't mention the appointed agent at all, what would you do? Let it go or call the funeral home?
So the agent form, unless the form said, I want you to use this specific funeral home, there's nothing in the law that requires the individual agent to use the firm, even if there were pre-funds or pre-need arrangements with that firm, they can always use a different firm. So barring, I'm not surprised that the obituary wouldn't mention the agent form or mention the first funeral home. So at that point, unless you had a copy of the agent form and it said that they wanted specifically to use that funeral home, I would let it go. And then recognize that even if it was that particular funeral home and there were other factors like financial, that the second funeral home was able to do same stuff or very similar stuff for less, which was all that could be afforded, then that would give the agent the right to switch funeral homes anyway. So for practical purposes, I would say let it go because I don't see anything legally that they did wrong necessarily.
I think it's my understanding after reading this again is that so the deceased appointed an agent and that agent was not recognized at the new funeral home.
I get what you're saying. So the agent didn't get to control disposition in the new funeral home.
Correct.
So if that's the case, I mean, that's a clear violation if the agent now, unless at the time, unless you know the details of this, at the time when the agent was being asked to take control, if that agent was unwilling and unavailable, then that would be a factor to say it went to somebody else. So unless you know that the agent was willing, available, and basically ignored, then I think that you would just let it go.
Can an agent with the proper documentation be stopped from carrying out the deceased wishes to be buried with no formal services by the children?
And the agent, say that again, Kelly, I'm sorry, I'm just trying to.
No, that's fine. So let's say an agent was appointed and they went into the funeral home and they decided that, but the deceased had wanted no formal services. They appointed their neighbor to be their agent. The neighbor went in, this is what we're doing. And the children want formal services.
Gotcha.
Can they override the agent?
No. The agent is number one on the list. The agent is doing what the law says, which is honoring the decedent's wishes. The children can't force the agent to do something else. And if the funeral director did allow it, then they'd be violating the law because they're not acting reasonably and in good faith or based on the person who has legal control of the arrangements.
When mailing cremated remains via USPS, is the tracking number and or receipt an acceptable form of proof with regards to the customer's designation of intention? Because they said the families oftentimes don't sign that after it's mailed?
Yeah, that's like a little bit off of this topic, but um, I don't recall anything that indicates proof. So again, I'm going to go and fall back to what I learned in law school, which is whenever it's silent, you go to the reasonableness standard. So to me, if there's not a spot where they're signing off and you have tracking to show that you took the steps and you're doing all of the things to get it back to them, the remains back to them, I think the tracking numbers would be a reasonable step to take. But that's just me talking off the top of my head without looking at the law, in case there is anything. But I am not aware of anything in the law that says you have to do more.
Okay, what if there is only a stepchild, but also a close friend who knows the loved one's final arrangement? Does the close friend supersede the stepchild?
Yes, because the stepchild has no authority under the law. They don't fall under the definition of child. So if the only connection to the decedent from the stepchild or relationship is as a stepchild and they don't fall into anything else above close friend, then the close friend controls.
We know that a funeral director can't be an agent if they are going to be making money on the funeral, but can the funeral home actually hold the services?
The funeral home can hold the services, but so long as if the funeral director is the owner or, of the funeral home, then by definition, their business is making money. So that person's making money. So they couldn't do it. But if it's a licensed funeral director who doesn't have an ownership stake in the funeral home, then that funeral home can certainly do the services. Yes. And even if it was a situation where it was the owner, the funeral home can still provide the services. It's just that they can't do it for money.
Can you review again the separated spouse law when concerning final disposition?
So there is two ways that a marriage can end, officially end or legally end. One is divorce and one is legal separation. A legal separation is, for all intents and purposes, a divorce. It's an agreement that a court would issue that would actually deal with all the different arrangements as it relates to the couple separating. So the real difference is usually as it relates to financial obligations when there's children involved, and sometimes people get legally separated as opposed to divorced for that reason. So that's the two. So they would have to either prove that they're divorced, and there's papers showing that, or they'd have to have a legal separation agreement. Barring either of those two, the individuals are still legally married, and therefore that spouse is still the legal spouse for purposes of final disposition.
Do we have to go to the court to obtain the court decision, or make the family do it?
I would say have the family prove it to you. They're the ones claiming this stuff. Again, you're not the investigator. If they're going to make this claim or try to prevent somebody from making a claim, have them provide the proof to you.
Okay, I think we already reviewed this, but so we spoke about the regulations regarding the funeral director not being able to handle disposition and financially benefit when they are an agent. Does that apply for burial as well as cremation? What if the deceased is a family member of the funeral director handling the services?
So it does apply to any form of disposition. It's just that you can't be designated agent. If you're a family member, then I guess my recommendation would be don't be appointed an agent if you're going to be a family member who would have control anyway, because the law that prevents you, the way the law is written, the preventing you from being able to receive a financial benefit is if you're the agent. So if it's a other family member and you're handling it on that on behalf of them under those arrangements, or even if you're not in control but your firm is handling it because it's a family member, there's no restriction on making or any money or financially benefiting from that. It's just when you're the agent. And the rationale there is if you're the one in control of disposition as an agent, you're no one else above you. You could theoretically, without a lot of, if there's not a lot of direction from the decedent, that you could run up a very expensive funeral bill and then charge that to the estate. And I think that's the intention there, is to prevent those kind of misappropriation of funds, so to speak. So just in the situation, so it applies to any kind of disposition. But if you're a family member or you're handling it for a family member, if you're not in control and the other family member is, then your funeral home can certainly do it and do it as under normal circumstances where you charge a fee. And if you're going to be the family member who would otherwise most likely have control, and it's an issue of control, then just don't be appointed the agent and wait until you fall under one of the other priority listings to have control, because again, the law only prevents you from doing it if you're the agent.
What are you supposed to do with the unembalmed body while you are waiting for a court order or for the dispute to be settled?
Yeah, that's a tricky one, right? Because if it goes too long, then it becomes a public health issue. The answer we have gotten from the Bureau is one of two things. One is find, if you have the ability to refrigerate or store or find another place, you could charge the family for that as long as you tell them ahead of time while they're waiting. Or if you said, look, if you're going to use us while we're waiting, we can't let your loved one's remains go unembalmed because of health issues and for other things. So if you want, we'll wait, but you have to agree to let us embalm. And again, you have to have them agree because it's not required by law. And then that would give them the option of going somewhere else instead. So those would be the two options that I can think of.
When a person with the right to control refuses, should you ask them to sign something saying that you can move on?
I would always advise that. And it doesn't even have to be, you can even have them just send you an email that says, I'm so-and-so. This is my relationship with the person. I am, disclaiming or refusing to control, or I have no interest in controlling, just anything in writing. So they can't go back and say, if I had known, no one talked to me and told me that I had control or I would have done it. I would always recommend to have, anytime you can get something in writing, get it in writing. And it doesn't have to be formal. It can be on a piece of paper. It can be in an email. I like email because it's easy to keep in an electronic file. You don't have to worry about losing it. It's dated, all that kind of stuff. So yes, my answer is yes, get it in writing if you can.
If one of 3 children come to handle disposition of the body and siblings don't get along with each other or have no contact with other siblings, do we need to pause and get a court order?
So the law now says you need 2 of 3 to move forward. If you can't get 2 out of the 3, the only other way you could get around it, again, is reasonably you're reaching out and neither are available or they're unwilling to respond. If you show that you've made those efforts and you cannot contact them and you have one who's willing, then you can move forward with that one because you're protected, because you took the reasonable steps, and you're going to rely on the fact that the others who would have had to agree are not available or unwilling. If they're just being difficult and you know how to get a hold of them and they're pushing back, then my recommendation would be to pause, because that's when you take the steps with the one and somebody sneaky is going to come back and say, they didn't have the right to do that. I was just disagreeing with that they were choosing, and they should never have moved forward. So I think it's a fine line you have to kind of draw. So whenever in doubt, pause. But if you've made the effort, you can show you did, you can't get a hold of them, they're unavailable, then yes, I think if you can document that you took those steps, you've done the reasonableness that you're required to do, and you're good to move forward.
Okay, Mike, a couple more.
Okay. Okay, I just filled up my drink glass.
Would the child be the next of kin? If the spouse is institutionalized for dementia and there's no power of attorney, would the child have the right to control disposition?
So that would probably fall under the not competent. So as long as you can show that, yep, here's proof that this spouse was institutionalized and this is the reason, then yes, you would say, okay, that person is no longer available, go down the list. Child's next and available, then you can work with the child. So just get something that shows that the spouse, that what the circumstances are, you can stick in the file to prove if anybody came back to you later saying that this person was really available. And you can say, nope, they weren't. Here's the proof.
Okay. When the agent signs accepting being an agent at the time of appointment, and at the time of death, the agent has already passed, where would the successor sign to accept becoming the agent?
So what we basically do is we would say, get the agent form, show it to the successor, and then just print off that last signatures part again, the page at the bottom. You can cross out anything on the top part of it. Just have the successor sign at the bottom where the original agent signed, basically accepting it, and they'll date it, and then just staple it all together, and you have what you need to move forward. Because the original form will have the successor's name, and then you're getting the agreement of the successor at the time of need to agree to take on the responsibilities, and you put it all together.
Okay, so this is a hypothetical. We have two siblings who disagree on disposition of a parent to the point we request a court order to proceed. One sibling contacts another funeral home to take possession of the parent. Do we release the decedent to that funeral home, or do we wait and get the approval of the other sibling?
My recommendation would be to notify the other sibling that this was requested, to find out if there's any objection. If there is an objection, to go back to the sibling that asked for this to be moved and say that your brother or sister is not agreeing to this, so I'm going to pause until I get someone telling me which direction to go. And if they've already contacted the other funeral home, I would call the other funeral home and just let them know, hey, this is the circumstance, so here's the situation. Cover all your bases so that no one's coming after you later on.
Okay, if a child is awarded to the state, who controls disposition?
If a child is awarded, so that would be the legally appointed guardian if they're a ward of the state. So whoever that person's guardian is, and it would be the person. I think that's number 6 on the list.
Okay, that's the end of the questions. So thank you so much, Mike. I think this is really informational every year. And I want to thank everyone for staying on. It looks like most of you did stay on for the entire hour and 24 minutes. So we definitely appreciate that. We appreciate your patience with us. And again, we will get your portal reflective of this credit in about 5 to 7 business days. Thank you so much, everyone, and have a great afternoon.
Thank you all.